You can be smart and still do stupid things. Let me tell you about a phone call I got a few years back. A woman called me, sharp lady, very together, and she said, "Tom, my brother and I need to sell my mother's house. She passed 2 months ago, and we need to move quickly." Normal enough, right? I hear that call all the time. So I ask her a few questions, and within 5 minutes, I realized this family is in serious trouble. Mom had added the daughter to the deed years earlier to make things simpler. There was no trust, no planning, and the will that Mom was so proud of, the one the whole family knew about, she had written notes all over it. Changes she meant to make, things she wanted to update. In the state of Florida, that was enough to create a serious problem. Florida does not recognize handwritten changes to a will unless they're signed and witnessed all over again, the same way the original was. So now you've got a document where nobody can tell what Mom actually intended. And where nobody can tell what Mom intended, attorneys start arguing about it. And when attorneys start arguing about it, the meter is running. The family is paying for that confusion by the hour. That house sat frozen for 19 months. 19 months of paying property taxes, 19 months of insurance and utilities and maintenance on a house nobody could touch. And at the end of it, after the attorneys and the court costs and the carrying costs, the two kids split what was left. Mom worked 30 years for that house. 30 years. And here's the question that should keep you up at night. Is that what's waiting for your kids? Because I can tell you right now, the people who create these situations are not careless people. They're not irresponsible people. They are people exactly like you. People who worked hard, bought smart, and just never got the right information at the right time. I'm Tom McNamara, Florida Real Estate Insider. Stick around because in the next 10 minutes, I'm going to walk you through the 6 most common ways good people accidentally wreck their kids' inheritance. And more importantly, I'm going to tell you exactly what to do about it. Before we go any further, hit subscribe and ring that bell. Next week's video is on mistake number 1, the early title transfer trap. I'm going to show you something called a ladybird deed that a lot of Florida families have never heard of, and it could save you serious money. You don't want to miss that. As always, I am not an attorney, and this is not legal advice. Everything I tell you today is the beginning of your education. A qualified real estate attorney licensed in your state is the end of it. We good? All right, let's go. Let's talk about why each one of these is such a problem. Number 1, the "I'll just add her to the deed" move. This one kills me because it comes from such a good place. Mom wants to make things easy for her daughter, so she adds her to the deed. Done, right? Wrong. Here's what just happened. That daughter no longer inherits the house. She receives it as a gift. And gifts don't get what's called a stepped-up basis. That means when Mom bought the house in 1985 for 45 grand, and it's now worth 450 grand, the daughter now owns a $45,000 house on paper. When she sells it, the IRS is going to want a conversation about $405,000 in gains. Mom was trying to save her daughter stress. She just handed her a 6-figure tax problem instead. Always consult with a state-specific real estate attorney before you touch that deed. Mistake number 2, the $20 legal form. Look, I get it. You found a deed form online. It looks official. It's got blanks to fill in, and the attorney down the street wants $800 to do what seems like the same thing. Here's the problem. One wrong word, one missing legal phrase, one notarization that wasn't done exactly right for your county, and you've got what's called a clouded title. I have personally watched a family try to sell a home for over 2 years because of a DIY deed that wasn't done correctly. 2 years of carrying costs, maintenance, taxes, all because someone tried to save $800. That is the most expensive $800 you will ever not spend. Always consult with a state-specific real estate attorney. Mistake number 3, the reverse mortgage time bomb. Reverse mortgages aren't inherently bad. For the right person in the right situation, they can make a lot of sense. But here's what a lot of families find out too late. When the last borrower passes away, the clock starts, and it starts fast. Heirs can have as little as 30 days to notify the lender and start figuring out what they're doing. After that, you're looking at foreclosure proceedings. Most families aren't prepared for that. They're grieving. They're dealing with a funeral. And somewhere in the background, the lender's timeline starts ticking. There's something called the 95% rule that can actually help heirs keep or settle a home at a significant discount. But if you don't know it exists, you can't use it. Always consult a state-specific real estate attorney and know what kind of mortgage is on that house before someone passes. Mistake number 4, but I have a will. This one drives me absolutely crazy because it's so wildly misunderstood. A will does not keep you out of probate. I want you to hear that again. A will does not keep you out of probate. A will is literally an instruction manual for a judge. It tells the court what you wanted. The court still has to process it. You're still going to probate. And in Florida, probate on a $500,000 home means statutory attorney fees that can start around 15 grand. And that's before court costs. All in, probate can eat 3 to 7% of your equity. On a $500,000 house, that's up to 35 grand that could have gone to your kids. Gone because of misconception that a will was enough. And remember that woman I told you about at the beginning? Mom's will didn't just send the family to probate. It came with a whole new set of problems. All those handwritten notes she made in the margins, the things she crossed out, the changes she meant to make, none of that was legal. Florida does not recognize handwritten changes to a will unless they're signed and witnessed all over again, the same way the original was. So now you've got a document where nobody can tell what mom actually intended. A will is not a living document you update with a pen. If you want to make a change, you sign a new one, or you sign something called a codicil, which is a formal amendment, and it has to be witnessed just like the original. That's it. Those are your options. Anything else is just a mess waiting to happen. Always consult with a state-specific real estate attorney about probate avoidance strategies. And please keep that pen away from your will. Mistake number 5, assuming the tax bill stays the same. Florida homeowners have something called the Save Our Homes cap. It limits how much your assessed value, and therefore your property tax bill, can increase each year while you own and live in the home. It's a great benefit, but it travels with you. It does not transfer to your heirs. The moment that property changes hands, the county reassesses it at current market value. I've seen heirs go from a $2,000 annual tax bill to a $12,000 annual tax bill overnight. And if they weren't planning to sell, if they were planning to keep the family home, that number can make the decision for them. Always consult a state-specific real estate attorney and a CPA about what the real carrying costs will look like after a transfer. Mistake number 6. My kids will figure it out. Here's my favorite, the one I hear the most often. Tom, my kids get along great. They're not going to fight over the house. Maybe, probably even. But here's the situation you're creating whether you mean to or not. When you leave a home equally to 3 people, each one owns a share. That's called tenancy in common. And here's a problem with tenancy in common. All 3 of them have to agree on everything. Want to sell? Everyone has to agree. Want to rent it out? Everyone has to agree. Want to do nothing and just hold it as an investment? Everyone has to agree. And if they don't agree, and I mean even if one person doesn't agree, any one of them can file what's called a partition lawsuit. The court steps in, forces a sale, and that sale is often at auction, below market. And then the legal fees come out of whatever's left. I want you to hear from my friend Joe Siegel. Joe is a Florida real estate attorney I've worked with for over a decade. Here's what he sees from the legal side of this.
Tenants in common is the default. Tenants in common is you just own the properties together.
Right.
I call it a partnership. You all have equal say in what happens. And then if there's an argument, the way it's handled. If you can't work it out, then you go through a real property divorce called a partition.
It's a partition lawsuit.
Yes,
Yeah, I've
and
heard
you
of those.
sue each other to say, "Hey, judge, tell us to either sell the property, or if it's farmland, sometimes they can physically divide it by new boundary lines and give you acreage
Okay.
to divide it up." But that's very rare. Most of the time, it's sell the house. Which at that point, the vultures start to circle because they know this house is being sold under duress, and we're going to get a great price because these kids are all fighting with each other.
That is exactly right. And I've seen it play out exactly that way. Families who genuinely liked each other walking out of this process, not speaking, over a house their parents left them as a gift. Partition lawsuits can easily consume 10 to 15% of the home's value in legal fees alone. On a $400,000 house, that's $40,000 to $60,000 that just evaporated. Always consult a state-specific real estate attorney about how to structure ownership before it's a problem. Here's the thing about all 6 of these mistakes. They're completely fixable right now, today, with the right legal help and just a little planning. But the window closes once a parent has passed away or has lost the mental capacity to make legal decisions. Most of these options are then gone. You're not planning anymore, you're reacting. And reacting means you're probably paying property taxes, insurance, and maintenance on a house that's frozen in a court backlog for months, sometimes longer. The families that get this right aren't smarter than you. They just did it before they had to. So here's what I want you to do before next week. Pull out the deed. Seriously, do you know exactly how the home is titled right now? Do you know if there's a mortgage on it that has conditions attached? Because if you don't, that's where we start. If you're in Florida and you've got a question about a property, whether it's a valuation, a title question, or you just want to understand your options, reach out. Link is in the description. I'm happy to point you in the right direction. And next week, we're going to deep dive on mistake number 1. I'm going to explain exactly why a quitclaim deed is often one of the most expensive mistakes a family can make. And I'm going to introduce you to the Ladybird deed, which is one of Florida's best kept secrets for keeping the IRS out of your family's business. This has been the Florida Real Estate Insider. I'm still Tom McNamara. I'll see you in the next one.